Thank you all for being here. We are excited to share our presentation about disparate impact in rural communities. Yeah, you can go ahead and slide, please. So I'm Emily Hammond. I use she, her pronouns, and I am the Education and Outreach Coordinator for Central Oregon for the Fair Housing Council of Oregon.
Hi, my name is Marlee Baker. My pronouns are they, them. I'm an education outreach specialist for the Portland Metro and City of Salem regions. I also am a tour guide for our historical bus tour Anywhere But Here. And it's a pleasure to be here with you today. We're excited to get started.
Slide, please. All right, so before we get going, I'm going to kind of dive into some of the background and tell you a little bit more about Fair Housing Council. So we are a statewide civil rights nonprofit. We're not a government-run entity, and our mission is to eliminate housing discrimination and ensure equal access to housing choice. And Fair Housing Council of Oregon has been in operation for 33 years, so it's been doing this work for quite some time. And I have been with Fair Housing Council since April, so I am newer to this work, but I'm excited to be here with you all today. We have two main departments. We have the education and outreach team, which is where Marlee and I work. And a lot of that work is doing education across the state. And we educate not only advocates, but also consumers of housing, people who are looking to buy a house or rent a house, or people who are already in housing and are just looking to be more aware of their rights, things like this. We also have an enforcement department, and they do more direct advocacy if we're seeing issues of housing discrimination. And so, yeah, these are our two main teams, and we provide advocacy services regardless of income or immigration status, and don't charge fees for any of these advocacy services. And sometimes our trainings and presentations do come with a fee, but we can often do trainings that don't have a fee depending on our grant funding at the time. Slide, please. So during this presentation, I'm gonna dive into fair housing basics, kind of give you the foundations of that. Then Marlee is going to talk about a history of discrimination in the state, which is really fascinating, and then dive into disparate impact, what that is, and some specific case studies of this. And then I'll kind of tie it all together by talking about some different ways we see this showing up in rural communities. And hopefully we'll have enough time at the end for questions. So please hold your questions till the end, and we'll hopefully have some juicy discussion. Slide. So what is fair housing? Fair housing is the right of all people to be treated equally in the rental, sale, or financing of housing. So therefore, it is illegal for housing providers to discriminate based on protected class. And I'll unpack these terms a little further here in just a minute. Slide, please. So we all have likely different definitions of what discrimination is based on our lived experiences, but for the purpose of our presentation today, we're going to use this definition, which is treating a person differently in any housing transaction because that person is a part of a protected class. So what is a protected class? So we have 7 federal protected classes. Those are race, color, familial status, sex, religion, national origin, disability. The first 4 were added in the 1960s during the civil rights movement. Familial status was added in the 80s. And up until 1987, any landlord or housing provider in the US could deny to rent, lease, sell, or anything to children with families. So oftentimes listings would say no children, no pets, things like this. In Oregon, nearly 70% of the rental market was blocked to people with children before familial status was added. So this was a huge step forward with adding this as a protected class. Then we have sex, which was added in the 70s during the women's rights movement. And before this, landlords and housing providers could refuse to rent or sell property to women because they might assume that she might not make enough money to pay rent, or that she might need a man to keep up with maintenance, like mowing the lawn, things like this. Then we have in the 80s, disability was added as a protected class during the independent living movement. And before this, many people with disabilities lived in group homes or congregate settings. So in the 80s, when people with disabilities looked to find homes in the community, they found that discrimination was rampant and was a huge barrier to getting housing. So we can see that fair housing evolves as we learn more about discrimination trends and we identify new groups of people who are experiencing these disparate barriers when accessing equal and safe housing. Slide, please. So not all states have this, but Oregon has its own additional protected classes. We have marital status. So, if you're single, married, divorced, widowed, none of these factors should be taken into account. We have source of income. So if an individual is receiving Section 8 voucher or any other kind of state, local, or federal assistance, this must be considered a source of income. So while temporary assistance for needy families, supplemental security income, Social Security disability insurance are not explicitly written into this protected class, the legislative intent was to include these. And one thing to note is that we do frequently hear about landlords straight out refusing Section 8 vouchers or refusing to rent to people who are getting services or financial aid from an agency. And this is absolutely illegal under Oregon fair housing law. So if you hear about this happening, let us know and we'll have information about how to contact us at the end. Then we have sexual orientation and gender identity, and these were added actually before it became a federal mandate. And then some cities or regions also have identified additional protected classes. So Multnomah County added occupation, which means that our job, not what you do, and your age should not be a factor in any sort of housing transaction. So some occupations are discriminated against more than others. So maybe, for example, exotic dancers or lawyers, things like this. And then age over 18 was added in some college towns because of the rule stating must be 22 years or older, disproportionately impacts college students. So if you're interested in learning more about this, you can go to our website and we have a lot of resources there as well. So tying this back to our definitions, fair housing laws are civil rights laws which promote equal access to housing for all people, regardless of their protected class identity. Slide, please. And you can go again, please. Thanks. So fair housing law applies to anyone who touches the housing market. So this could be owners, landlords, property managers, maintenance staff, homeowners associations, real estate agents, banks, insurers, neighbors, jurisdictions, advertising media, pretty much anybody. Slide, please. And fair housing is protected in all types of dwellings. So this looks like houses and apartments, condos, floating homes, mobile homes, retirement homes, or retirement housing, assisted living, nonprofit housing, possibly even motel rooms, depending on the intention and the length of stay. Slide. So when determining if something is discrimination, it's important to understand that the places where landlords can treat somebody differently. So for example, residents who violate their rental agreement by maybe not paying rent on time or disturbing their neighbors, damaging property, or doing illegal activity on the property. So again, landlords need to have consistent rules and procedures and not treat somebody differently based on their identity. So if they're allowing one tenant to pay their rent late each month, for example, they should be letting everybody pay their rent late each month. So for example, if a tenant, and if not, they need to have clear documentation that states why one person is getting different treatment than the other. So this could look like maybe a tenant receives disability funds on the 15th and thus requests a reasonable accommodation that they pay their rent on the 16th versus the 1st. So now I'm going to pass it over to Marlee, and they're going to dive into the history of housing discrimination in Oregon.
Thank you, Emily. We can go ahead to the next slide. So I want to spend some time before we talk about disparate impact, talking about the history of housing discrimination here in the US and here in Oregon. So that way we understand how disparate impact fits into the framework of fair housing today, and how it can be used to identify seemingly neutral policies that may actually have a discriminatory effect against protected classes. So this is a picture that I'm sure we are all pretty familiar with. If we attended school here in Oregon or somewhere here on the West Coast, this is a picture of the idea of manifest destiny. So the history books typically frame the Pacific Northwest and Oregon as this Wild West, a place that was mythical, didn't have any, it was like ripe with gold. It was an occupied landscape. It had the potentiality for agriculture and industry. But this framing of history is very untrue. In fact, Oregon has been home to over 60 indigenous tribes and bands for over a millennium. And most of that population lived in what is presently known as Oregon. They were concentrated near the Columbia River, the western valleys, and water inlets along the coast. Early Oregon settlement was largely shaped by this idea of manifest destiny, that it was white, European, and Protestants' rights to go forth and conquer the Wild West. And this idea goes all the way back to the 1792 Doctrine of Discovery, which claimed that US or European countries had an overriding sovereignty over the sovereignty of the people who were indigenous to the land. Next slide, please. So we're going to do a crash course of about 100 years of history real quick. In case you're not familiar, in 1848, Oregon officially becomes a US territory. And Oregon's early political and economic systems were established with the intention of creating an agricultural paradise in the West, where white farmers could settle without the competition of Southern plantation owners. And this vision is reflected in the original state constitution, which banned African Americans from owning real estate or land or voting. And in fact, this explicitly racist language was not removed from our Constitution until 2002. In 1849, Oregon passed official legislation for this, the Black Exclusion Law, to bar African Americans from owning property or being residents. And this law would not be repealed until 1927. This act, and then we have the 1850 Donation Land Claim Act. So African Americans are barred from entering Oregon. However, at the same time, Oregon issued this act, and this act invited white farmers from across the United States to come and settle in Oregon, promising them 160 acres if they arrived between 1850 and 1855. This number would be doubled if they were married. And if they had previously been living in Oregon prior to 1850, this number was 320 acres, doubled again if they were married. Today, we estimate that that is equivalent to a $2 million subsidy. The idea behind the Donation Land Act was to invite white farmers to Oregon. Oregon previously, before this, was primarily occupied by fur trappers. It's a very nomadic economy. And so this allowed a lot of individuals to come and set up properties here in Oregon and systematically push out the indigenous tribes living there. And this worked between 1850 and 1855. The Oregon settler population grew from 13,000 to 52,000 people in just 5 years. And to reinforce the protection of ownership of land even further, the sole white ownership of land, in 1866, Oregon passed the miscegenation law, which criminalized interracial marriage. And a part of this was also to prevent non-white wives from inheriting land from their white husbands. Then in the 1850s, we see a rise of Chinese immigrants entering into Oregon. They worked in fish canneries, like in Astoria. They helped build a lot of Oregon's early infrastructure, like the roads, a lot of the roads that we use. In 1859, the Oregon Constitution included a clause to prohibit Chinese individuals from owning real estate, a law that would not be repealed until nearly 100 years later in 1943. And in 1882, the United States at large introduced the Chinese Exclusion Act, which prohibited the immigration of Chinese laborers for 10 years. And today, the focus of this presentation is on disparate impact, right? We're talking about neutral policies. These are very explicit policies that banned certain populations that we now identify as protected classes in the US from owning land and accessing housing. But there were also cases of disparate impact even back then. So I'm going to be passing around a piece of paper, and I found this while doing research in Astoria just a couple months ago, and this is from the Astoria Municipal Codes in 1896. And here in section 14, it bans people from carrying baskets suspended on poles. Now, who might be, this seems, I'm going to read it to you. It sounds very neutral, right? If any persons shall carry any basket, buckets, bags or bags, on any other thing suspended or attached to poles or across the shoulders, this would be offensive to any pedestrians upon any sidewalk, and they shall be deemed guilty of a misdemeanor, and upon conviction thereof before the police court shall be punished by a fine no less than $5, no more than $300, or by imprisonment in the city jail, not to exceed 100 days. Now, what population in Astoria might be peddling fruits and vegetables and things grown in their garden in a way that they would be carrying baskets upon their shoulders? Well, primarily the Chinese population there in Astoria. So I'm going to pass this around so you can take a look at it really quick. It's located on the bottom. There you go. So we see this rise of anti-immigrant sentiment, and this continues into the early 1900s. By 1910, nearly 14 million immigrants had come to the United States, and in that same year, it was recorded that nearly a third of US residents were either born abroad or were first-generation citizens. In 1923, Oregon passed the Alien Land Law, which blocked Japanese citizens from owning land, and this was a direct response to the increase in success of Japanese farmers. Then in 1924, there was the Immigration Act, which set quotas based off of ethnicity and skin tone and cultural national origin. And this dramatically reduced immigration from Southern and Eastern Europe, and it showed a clear preference for people from the British Isles and from Germany, and virtually no Asians, Africans, or Arabs were allowed to immigrate to the US during this time. And in fact, because this law was not repealed until 1965, this also prevented many Jewish immigrants from being able to escape the Holocaust by coming to the United States. Next slide, please. So those quotas very much reflect the racial hierarchy that had been created and promoted and enforced within early America. And in the 1920s, the American Institute of Real Estate Appraisers issued a list of the top 10 desired homeowners that reflected these immigration quotas that were nationally ranked at the time. So this is a direct list that was taken from the American Institute of Real Estate Appraisers, ranking groups based on most to least favorable. And this was used from the 1920s through the 1940s. So we can see how property value becomes determined not just by the quality of brick and mortar, but also by neighborhood composition, by who's living in those spaces, right? And the Federal Housing Authority played a large role in perpetuating these segregated hierarchies. Next slide, please. During the Great Depression, the Federal Housing Authority innovated home buyer practices to increase access to home ownership and wealth creation. At the time, this was a really good thing, right? People needed access to homes. So before this innovation, you could put 50% down, and then it would take about 5 to 10 years to pay off the balance. But with this innovation, you could buy a home with 20% down and then pay the rest off after using like a 30-year fixed rate mortgage. However, this innovation to streamline home ownership was limited mainly to just white men. Between 1934 and 1962, the banks underwrote nearly $120 billion in loans, with fewer than 2% given to non-whites. White men essentially received all of the loans approved by the federal government during this time between 1934 and 1968. In 1936, the Federal Housing Authority published the Underwriting Manual, and this was to be used by appraisers during this loan risk analysis to determine if someone was qualified for a loan. Next slide. However, within this underwriting manual that was published by the Federal Housing Authority, this group, this statement kind of creates the framework for how they would create those policies. Incompatible racial groups should not be permitted to live in the same communities. And they did this through two different ways. They enforced this through two different ways, the restrictive covenants and racial covenants. So restrictive covenants prevented owners of real estate from selling or transferring property to Black people or other racial minorities and various religions. So this means even if someone qualified for a home in a neighborhood that they wanted to live in, because of their race, they would not be able to live in that area. And in fact, these restrictive covenants are found in the deeds of homes. So if you own a home prior to 1948, it's very likely that in the deed of your home, there is a restrictive covenant in it. Additionally, these restrictive covenants sometimes also said that an all-white neighborhood would be defined by no people of color within a four-block radius of that home as well. So these were restrictive covenants, and then there were racial covenants, which were just agreements made between local real estate agents to ensure that non-white populations would be kept restricted to specific neighborhoods. And they did this because they believed that selling a house in a white neighborhood to a Black family would adversely affect neighborhood property values. And this practice was legitimized under the myth and the racist belief that racial integration of communities would introduce crime, race riots, violence, and therefore it would be safer and best practice to maintain segregation. Now, this is guidance coming directly from the Federal Housing Authority guidebook published by the government. Desegregation was considered a professionally irresponsible act, and these mortgage lending policies prevented most residents within Black neighborhoods from owning their own homes, leaving entire groups of minority renters vulnerable to the full press of gentrification and urban renewal in future years. So, next slide, please. This is an example of a restrictive covenant found in the deed of a Portland home. It says, no person of any race other than those of the Caucasian or white race shall use or occupy any building on any lot, except that this covenant shall not prevent occupancy by domestic servants of a different race domiciled with an owner or tenant. Next slide, please. Redlining was also a common form of segregation enforcement during this time. And in fact, we sometimes see it today, although we identify it using disparate impact, which I'll get into in just a little bit. So redlining was a prevalent practice which would rate neighborhood stability by the population of people of color or new immigrants who were living there. Neighborhoods where people of color and new immigrants lived were outlined with a red line on planning maps, while neighborhoods with primarily white residents were outlined with green lines. And this rating system was used to deny loans and homeowners insurance to those living in those redlined areas, which were deemed as dangerous investments. So you'll have access to these slides, of course, as you'll have access to everyone's slides, but they're also located in packets on the table. And it might be a little too small to see, but it's interesting to zoom in. And if you're from the Portland metro area, to identify how your neighborhood was zoned during this time. Another thing that was promoted by the Federal Housing Authority within their underwriting manual was the use of transportation projects to enforce segregation in communities. And transportation improvement projects looked like the creation of highways, which would be built over Black communities, demolishing areas that they deemed to be blighted. And we saw this particularly as well with urban renewal in the Albina district here in Portland. And there was also urban renewal in Eugene, where the Ferry Street community was built. And a bridge was built where that Black community was living, and their homes were demolished within 30 days of learning about this new improvement project there. So this is our current system. Next slide, please. We operate, hold hold on. Oh, yes. This is our current system. We operate today in a society that's been shaped, obviously and not so obviously, by discriminatory policies and structures. These instructions came from the top down, and they influence the way that we understand housing today, and even the ways that we build policies related to housing, implicitly or explicitly. Now, explicitly, we don't see discrimination in the same ways as we did back then, and this is largely due to the civil rights movement in 1960s. So the passage of the Fair Housing Act was the hardest piece of federal legislation to pass during this time. And this is because many people didn't want the federal government intervening with their homes. They believed their homes were their right, where they lived and who they chose to be their neighbors. That was their right that the federal government wasn't allowed to intervene in. But the Fair Housing Act was passed. It addressed both discrimination and segregation. And even though it was passed in 1968, it was not enforced until 1988. So 20 years later, enforcement mechanisms were created to make sure that people were following fair housing law. Next slide. And I share this all with you because it's important to understand how disparate impact fits into how we understand housing discrimination today. Disparate impact is a way that allows us to identify leaks in the structure, right? So we all have to function and work and create policies within this system that have been largely shaped by this history of discrimination. And though we can do really good work in identifying what's explicitly disparately impacting protected classes, sometimes leaks come through, right? Sometimes we pass something in good faith, and then the effects disproportionately affect certain protected classes. And so that's the system, that's the history we're operating under, and that's why disparate impact is so important. Next slide. Next slide, please. All right, so let's get into what is disparate impact while you're all here today. So disparate impact, how many of you have heard about this word with regards to fair housing? Raise of hands. Oh, wow, a good about half. Wonderful. So we're going to do deep dive into disparate impact today. Next slide. There we go. So disparate impact is defined as a liability for practices with an unjustified discriminatory effect, even if those practices were not motivated by discriminatory intent. So even if someone was not specifically trying to cause a discriminatory effect, even if that's not in the housing provider's intention, even if that's not in the jurisdiction's intention in creating perhaps zoning laws or policies, sometimes disparate impact can happen. And under fair housing law, we can hold those entities accountable for the discriminatory harm that has been caused. Next slide. So another way of thinking of disparate impact, it's a neutral policy that, when put into practice, has a greater negative effect on one group of people of a certain protected class more than another group of people. Disparate impact is also defined as any sort of policy that creates, increases, reinforces, or perpetuates segregated housing patterns. Next slide. So how do we determine disparate impact? Well, it's not as simple as conducting just a brief investigation like we might do for other micro sort of housing discrimination situations. I'm sure if you've worked in the field of housing, you've probably contacted the Fair Housing Council, hopefully at least once, with a question about, is this housing discrimination? Is this discriminatory? And sometimes we can give you a simple answer. Under fair housing law, it might be problematic that this is happening. But disparate impact is a little bit more difficult to define because it requires statistical analysis. So you can click, wonderful, and you can go through, I think there's 3. 1, 2, 3, yes. So disparate impact isn't as simple as having a criteria, and once you meet this criteria, it's disparate impact. It's actually, we use a burden shifting approach, and think of it like tennis. Where the burden of proof is shifting between the plaintiff and the defendant and then back to the plaintiff. So we're going to get into what are those stages during a case. Next slide. So the first stage of a disparate impact case, the burden is on the plaintiff to make a prima facie case I might have said that wrong. I don't speak Latin. Showing using statistical evidence that a specific neutral policy or practice has had a greater impact on members of a protected class than on others. Next slide, please. We're going to get into what all this jargon means because I'm not a lawyer. I don't get paid enough for that, but I've broken it down a little bit for you. You can click through. All right, so what does prima facie means? Prima facie means at first glance. This means that it's obvious that housing discrimination is happening in this isolated instance. Next slide. Great, and we're going to be using statistical evidence, and you can click through. Yes, so when we're talking about how we define a robust causality, this means that it's a one-time decision that does not equal a policy, and evidence of pre-existing statistical disparities is not sufficient. I'm going to rephrase that because that's not actually what I wanted to say. Okay, robust causality. This means that statistics are being used to prove that this is having an effect that continues to happen. So disparate impact, a one-time decision by a housing provider would not fall under disparate impact, right? One time that a housing provider chooses to discriminate or acts in a discriminatory way, that's not going to equal something that a policy, right? So a policy has to be something that's being done multiple times over and over again. So they have to prove that this is something that happens consistently. And the disparity that they're identifying, right, the way this policy is playing out disproportionately on protected classes must be caused by that policy. So there has to be a connection being made. And this is to protect housing providers and other entities from being held accountable to really abstract large forms of systemic inequities that maybe they aren't necessarily at cause or at liable for having caused that directly. So really, it's just bringing it down, bringing the focus down to the specific policy that's being used here. Next slide. Great, and greater impact on members of a protected class than others. This means that comparison groups are going to have to be made, right? It's not enough to just prove that one group of people are experiencing a disparate impact. In order to prove a disparate impact, you have to be comparing that with a other group. Next slide. Next slide. Great, next slide. All right, so that's stage one, right? Proving that there's a statistical connection, there's a disparity happening, right? Between the policy, a specific isolated policy, and a protected class that's being disparately impacted by that. So if the plaintiff is able to carry its burden, then the burden shifts to the defendant to prove that the challenged policy or practice is necessary to achieve a substantial, legitimate, or non-discriminatory purpose. You can click. Great. So this includes assessing whether there are any laws that are limiting the defendant, and if those laws are creating any artificial, arbitrary, or unnecessary barriers. So this would look like, is this person following the law, right? An example of this. Let's say a housing provider has a policy where they require verification for any disability. Now, in fair housing, we include a caveat to that if someone's disability is evident, they need not provide verification of their disability. So let's say someone who has a seeing eye dog and is clearly blind is making a reasonable accommodation request, and then the housing provider goes, well, I don't believe your disability, I need to see verification of your disability. Even though they're technically following fair housing law, that policy is creating an artificial, arbitrary, and unnecessary barrier for folks with disabilities in accessing their reasonable accommodation. And if you're interested in learning more about reasonable accommodations today and how they specifically pertain to assistance animals, I'm going to shout out my colleague, Glenda Moyer, who will be presenting in which room? Oh, Idaho and Alaska. And my other colleague, Savannah, is in the back, and she will also be presenting on that in the next session. Next slide. So if the defendant satisfies that burden, then the burden shifts back to the plaintiff to show that the defendant could achieve the purpose supporting the challenged policy using another practice or policy that has a lesser discriminatory intent. So even if the defendant is able to prove, I'm following the law here, I'm not acting in a like I'm not intentionally being discriminatory, the plaintiff can prove, well, there's an alternative that you could have been doing that is less discriminatory, and we're going to hold you to that standard instead. And then if the plaintiff is able to do that, then they're able to satisfy that burden and they win the case. It is a disparate impact case. Next slide. So we're going to get into a couple examples of what disparate impact looks like. Next slide. All right. This is a study or a case that occurred here in Portland, actually, in 2019. And the Fair Housing Council actually played a little bit of a role in this case. So an African-American plaintiff visited a property and told the property manager that while she had a 600 and more credit score, her husband did not, but they were both employed and had a good rental history. Now, the manager reiterated that the credit score requirement was absolutely necessary. They both needed to have a 600 or more credit score. And even though they had good rental history, they both had sufficient employment, she did not, she kind of became cold and aloof after that. Now, she was actually tested by several different white applicants who were presented through the Fair Housing Council of Oregon. And when I say testing, I mean, it's sort of like a way of identifying discrimination through secret shopping. We give people false identities, they go forward and they test housing providers about their policies and practices to see if housing discrimination is happening. So this housing provider was tested by us at the Fair Housing Council of Oregon several times. And when presented with white applicants who had the exact same situation, their husbands had poor credit history, that housing provider would go forward and provide them information about how to go about getting a co-signer, how to raise their credit history, and was providing this information. And this happened multiple times. So because it happened multiple times, a policy was kind of created from that, right? It wasn't a one-time instance of discrimination. This was something that was happening over and over and over again. Next slide. Great. You can click through this whole slide, I think. Oh, we'll stop right here. Okay. So according to a study done by the Federal Trade Commission, 26% of African Americans had a credit score in the bottom decile of all credit scores, and only 3% of African Americans are in the highest decile of all credit scores. In contrast, less than 10% of white people have credit scores in the bottom decile, while over 10% of white Americans have credit scores in the highest decile. Additionally, African Americans make up approximately 20% of the total population in the bottom decile of credit scores, whereas African Americans make up only about 13% of the overall population in the U.S. requirement prospective renters to meet a minimum credit score. So, okay. Whereas African Americans only make up about 13% of the overall population in the U.S. So this means, giving these statistics, right, we're able to understand that barriers related to credit history might disproportionately impact African American tenants who are looking to access housing. Next slide. So requiring prospective renters to meet a minimum credit score disproportionately impacts African Americans. However, while this is a clear instance of housing discrimination based on race, right? The housing provider is clearly providing information to white housing applicants in ways that she's not providing to African American applicants. This was not actually a case of disparate impact. And the reason for this is because there has to be information about the demographics of that area, right? It has to be tied down really specifically. And so even though this was a fair housing case, there was compensation that was done, this didn't quite qualify for disparate impact. And this just kind of goes to show how difficult it is to identify disparate impact, and also why important it is that we are providing information about disparate impact to you all. Disparate impact is a really critical dimension of fair housing, but it's very underutilized, and it's also very difficult to prove. But the more times we're able to try this, the more times we're able to bring forward cases that might be disparate impact to identify those in our localities, we might be able to use this more. Next slide. Next slide. All right, let's go into a case that was actually disparate impact. So in 2017, the Equal Rights Center of Washington, D.C. alleged Lenkin Company Management Residential Incorporated were violating the Fair Housing Act and the D.C. Human Rights Act by refusing to rent available units to recipients of housing choice vouchers. Now, we know here in Oregon, source of income is a protected class, and this was a part of the movement to make source of income a protected class in D.C. So in its complaint, the Equal Rights Commission cited statistical data showing that a refusal to rent to voucher holders is 71 times more likely to exclude African-American renters than white renters. Next slide. Great. So according to HUD, 62% of housing choice voucher holders nationwide are designated as racial minorities. And though African Americans in DC, in this jurisdiction, this area, represent 48.3% of its overall population, 92% of housing choice voucher holders in the district are African American. You can click through. There we go. So a refusal to rent to voucher holders caused African American renters to be excluded close to 71 times more often. So we see here what's happening, right? There is we're looking at the demographics of the area, who lives in this area, who might be affected by this policy, and we're breaking that down into protected class. Next slide. Great. So this became a case of disparate impact. They were able to prove that a certain protected class within this area was being harmed more often due to this seemingly neutral policy, a policy to just choose to decide, I don't feel like renting to voucher holders, I don't want to rent to voucher holders, but this became a case of disparate impact. Next slide. So what does the consequences of disparate impact look like? What does the resolution of some of these cases look like? They were able to go through some good faith negotiations. And at the end of this case, they came to the conclusion that this property management would affirmatively marker units to voucher holders. They would disclose their tenant selection criteria to applicants before an application is submitted, so folks were able to identify if they qualified before paying those fees. They would also identify and train 2 employees to serve as housing choice voucher liaisons. They would hold open 30 days for any unit for which a voucher holder applicant to allow sufficient time for the housing authority to process that application. And they would undergo extensive fair housing training and civil rights testing, and they also would make a monetary payment to the ERC of $125,000. So education was made, changes to their policies were made, and there was also damages that were collected through the use of funding. Next slide. All right, now this is a case that has created implications nationwide. So we're going to talk about how disparate impact has played into criminal history. The Equal Rights Center issued a case against Mid-America Apartment Communities Incorporated and Mid-America Apartments LP, and this was in 2008. And in this situation, this housing group was excluding applicants with certain criminal records, including any felony conviction. And they also discriminated against folks who had any sort of arrest history as well on their record. Next slide. Now, this is definitely a disparate impact issue because we know that our criminal justice system has been influenced by systemic inequities historically, like some of the ways I described today, in the fact that Chinese peddlers could be arrested for simply peddling food using poles and baskets. And so historically, and even today, it's riddled with racial disparities. Here you can see that Black people were 4 times as likely as their white peers to be sent to jail. And we also know that an arrest record doesn't necessarily mean that someone has been convicted of a crime. They're just being held for that crime. So in denying any applicant who had any sort of housing, any sort of criminal history on their record, the likelihood of them discriminating against race was also heightened as well. So next slide. Great, you can click through. There we go. So African American and Latino housing applicants to these properties were between 2 and 12 times as likely to be prevented from applying for an apartment due to this policy. The overbreadth of the policy excluded many people of color without providing any greater safety or security to the tenants, particularly in light of other less discriminatory screening mechanisms. So it wasn't actually proven that in simply denying any applicant with criminal history, that they were actually creating a safer environment for all of their tenants. Just because someone has an arrest record, just because someone has a conviction, doesn't mean that they're going to create another crime. It doesn't mean they're going to commit again. So they had to change their policies, and they had to change their policies to be in line with HUD's guidance for criminal history that was published in 2016. So what this looks like is now, next slide. Click. Wonderful. One more. Great. I created a bunch of cool, I was gonna click it myself, fun little transitions, but now I just have to say the word click. Okay. So now these properties have to conduct individual assessments. So they have to review every applicant on a case-by-case basis. And they need to consider, and this isn't a suggestion, this is something that HUD outlines how housing providers need to do. They need to consider the amount of time passed since this conviction. They need to consider the severity of the crime. And they need to consider any sort of additional information that the applicant provides, such as a letter of explanation about how they've changed, about how they're going to be a good tenant, how this isn't going to influence their experience of being rented to. It also prohibits consideration of any sort of arrests, pending charges, expunged convictions, and reversed convictions. So in this example, this is a local policy that's being done, right? This is one property management's policy. Because this group was creating a disparate impact against the demographic of African Americans and Latinos living in that area, they had to change their policies to be in line with HUD's criminal history guidelines. Next slide. So I'm not going to go through the rest of these, but feel free to look them up on your own. But these are other examples of how disparate impact can show up within the realm and process of housing. So there was an instance of familial status disparate impact happening when a property management company was forcing families to vacate due to a 2-person bedroom unit policy, or 2 people per bedroom unit policy. Which was discriminatory if you had maybe a small child or 2 who could easily fit within that, that space without causing any sort of fire hazards. In 2016, there was a management that was sued for creating rezoning ordinances that perpetuated segregation by preventing affordable housing. So in these rezoning ordinances, they were allowing affordable housing to be built only in places where affordable housing had already been built. So they were sort of, what's the word? Reinforcing segregation in that sense, and that those individuals within that area who were needing affordable housing were more likely to belong to the protected classes of race and color. And because affordable housing was being forced in one area and not allowed to be spread out throughout the city, this was creating a disparate impact against housing choice. There was also an instance in a mobile home park where all occupants were required to document their legal status or be evicted. And this was an example of disparate impact against national origin. And then we also have Hunter Properties Incorporated here in 2023. So this is a very new case where any applicants with any eviction history would be automatically rejected. And in this area, in Chicago, it was more likely that people with eviction records were single women and single women of color. And so this became a case of disparate impact primarily against race, although an argument for discrimination against sex could also have been made. Next slide. So I show you all of that to sort of break down what disparate impact is. There, again, those three stages, that back and forth movement that needs to be happening of shifting the burden between the plaintiff and the defendant. And disparate impact is really helpful because it identifies when policies are unintentionally discriminatory, but are causing discriminatory effects. So Emily is going to bring it back to rural communities and talk about how disparate impact might be showing up in some of the places that you're living. And I'm going to pass it off to her.
Okay, thanks, Marlee. Yeah, so we just had kind of building the foundation, learned a lot about the history and different cases of disparate impact. But let's go ahead and unpack the ways that this shows up in rural and frontier communities. So one thing to note, as Marlee mentioned, is that disparate impact, even though it's a critical dimension of fair housing, it's definitely often overlooked, and this can be reflected in the lack of court cases and this being proved. So it can be really hard to prove that things are disparate impact. As we can see, this really complicated legal proceeding that you need to go through to prove that something is disparate impact. And so that's likely why we don't see as many court cases about it. It's not that it's not happening, it's just that it is quite challenging to prove. So because of this, we have to draw a lot of conclusions and discuss in hypotheticals because there's not a ton of cases about this specifically in rural areas. So in the next few slides, I'm going to kind of talk about some themes and different hypotheticals that we might see. So go ahead and next slide. Thank you. So although this photo is likely an exaggeration, according to the National Rural Housing Coalition, a disproportionate amount of the nation's occupied substandard housing is in rural areas. And additionally, more than 40% of all rural rental units were constructed before 1960. So this means that a large portion of the available low-income housing is quite old and doesn't have the same accessibility as newer units. So there are a few and also because there are fewer rental opportunities in rural areas than in urban spaces, and rental developments that do exist tend to have fewer units in them. So as a result of the age and the unit structure of these types of rental units in rural areas, this may push people who don't have other options to share small living quarters, and protected classes may be more exposed to housing discrimination in these ways, which I'm going to unpack further in the next few slides. So what does this mean and who does this impact? Next slide. So this is an anecdotal example, but we've seen issues like this pop up in our work and have lots of colleagues who have talked about this and shared with us. Immigrant farm workers make up an estimated of 73% of agricultural workers in the US. And this is just counting those who have a visa and who are counted in this demographic study. So the population, or this particular population, is one of the few groups whose housing is directly linked to their employment. And it's quite popular for employers to charge per head for employee housing at quite exorbitant rates in houses with many people due to this lack of housing in rural areas. And oftentimes because these workers are sponsored to be in the country by their employer, folks don't want to bring up any sort of issues because their housing is linked to their employment. And so maybe if they have their stove break or any other sort of mechanical or maintenance issue, they might just continue to live in these bad conditions because they don't want to cause any sort of conflict. And then pair this with the factor that there's oftentimes less economic growth in rural communities and less housing improvements. These groups of people are living in bad conditions in old houses and then often getting taken advantage of because of vulnerable situations, or likely not being able to communicate with their landlords. These folks are often likely to not look for supportive services to get help because maybe they don't have the access due to living in remote farmland, or maybe there's a language barrier. And so either with the services that they are looking for or with their landlord. And so then they also don't want to continue to push that barrier on their employer and lose money, their job, or things like this. So we can see the protected classes of national origin and disability being disparately impacted by situations like this because of barriers in resolving maybe a maintenance issue. Next slide. You can see here a map showing Oregon's rural, urban, and frontier population density, which so you can see in the white, this indicates the urban areas, light green is rural, so 10 or more miles from 40,000 people or more. And then the dark green are frontier counties with 6 or more people per square mile. Rural and frontier communities are harder at times to reach with social service support and for housing information because they don't have places like community centers or maybe hospitals, places like this for folks to gather. And people really have to rely on each other for the support that they may need. Oftentimes there's lack of transportation to these services. And another factor too is that oftentimes people don't want to get help from outside, maybe government services. Oftentimes for Housing Council is seen as a government agency. And because of this, it can be really challenging to disperse fair housing knowledge. So, and because of this, or a lot of ways, fair housing knowledge and enforcement relies on public awareness of individual rights and protections. And so if residents are not aware of their rights, and they're unlikely to know that they have been discriminated against and are less likely to take action because they may not have a trustworthy person to go to about the issue that they're facing. So the lack of fair housing infrastructure in rural areas limits individual access to the resources that we have and reduces the amount of information that's readily available to examine different needs in these rural communities. So in Oregon, within the first year of living somewhere, landlords have the right to serve an eviction without cause, but after the first year, they can only evict for certain stipulations. And since housing choice vouchers reflect fair market rent and often doesn't match the area median income, landlords feel unable to increase rent when renting to housing choice voucher recipients. So there's a rural community in Oregon where 8 different families finally got off the waiting list for housing choice vouchers, but they were evicted when the landlords realized that the voucher was a fixed rate. And additionally, even if source of income wasn't discriminated against, oftentimes people who receive housing choice vouchers fall under another protected class identity, kind of like Marlee was discussing earlier in the presentation. So these families, if families are living somewhere with lack of housing, fair housing resources, this discrimination, as in the evictions, can feel completely overwhelming and unavoidable. And without the public knowledge in these rural communities, people who fall under protected classes, who maybe have vouchers, can oftentimes get disparately impacted in these sort of discriminatory actions. Slide. So for my last example, this one hits very close to home. Another issue we see in rural settings is jurisdictions taking public opinion and being more likely to consider public input and not taking fact-based information. This can be seen in public pushback for shelter programs or low-income housing, things like this. So I just saw this happen in Central Oregon. I live in Bend. If you drive 10 minutes outside of Bend or Sisters, you can see images like this with tents and cars and RVs on public land in the forest just outside of town. So recently there was a proposal for an emergency shelter development in Sisters to address some of these social service needs in the community that I just found out last week was turned down. To me, their arguments seemed completely faulty, claiming lack of transportation, lack of medical resources in the community. Yeah, anyways, I went to a city council meeting where the proposal was shared with the opportunity for public input. And this tiny little Sisters building was absolutely packed with people who wanted to share their input. And it's a town of 3,000 people. There were probably, several hundred people there, more people online. It was very people were very riled up. And much of the argument that I heard against this project was how the development of the shelter services would bring in crime, even though it was maybe a block from the police station. And people from other parts of the state were said that they would come in to glean the resources from this new proposed shelter, and that the unsightly manner of the shelter would essentially defile the quaint Wild West-esque themed town of Sisters. So I don't know how many of you know about the point in time count. So I'll just speak to this very briefly, but this is a flawed but national metric that's used to count essentially unhoused people by the Housing and Urban Development. And this is done on a yearly basis. So although there are definitely issues with this count because of the teeny tiny snapshot that this gives into housing issues, we can use some of these numbers to draw disparate impact examples from this. So for 2023, there were 1,076 people unsheltered in Central Oregon. 46% of those people were older than 50. 46% of them were disabled. And 45% had lived in the community for over 20 years. A big narrative that I heard in opposing opinions for the shelter was that people were afraid that building a shelter like this would attract people from outside communities to get supportive services. But this is something called the magnetism myth, in case you're not aware. But you can see that there's a huge population of those folks who would likely be using these services who have lived and participated in the community for a very long time. So according to the US Census, the urban-rural age distribution reflects the out-migration by younger persons in search of better educational and economic opportunities and away from diminished labor opportunities related to rural farming and mining. So we can see more elderly people living in rural communities and less services. So when jurisdictions take input from the community or turn down supportive or emergency housing, this is a prime example of disparate impact, as we can see in these numbers here. Turning down the shelter is directly impacting the protected class of disability, as we can see in these pit count numbers. And but by turning down the chance for folks to have somewhere to get out of the elements, this is for an emergency shelter, and maybe get connected with resources to help them further get help into getting into permanent housing, get supportive services. So this is a huge, huge issue. Jurisdictions can listen to public opinion, but they can't make decision based on their opinions. They can't block housing choice for protected classes based on discriminatory comments from the public. So in this example, the City of Sisters caved to NIMBYism. And we've heard about this kind of thing happening all across Oregon. You can talk to any of my coworkers and they have heard of countless examples of this. Many of you are nodding your heads. I'm sure you have heard of this too. Yeah, so this is a big issue. Slide, please. So in conclusion, we are still building connections, and it's harder to reach folks who are living in tiny rural communities. Housing instability looks really different rurally than it does in the big cities. So it's really important to continue to consider how different policies or procedures of the past can maybe put an undue burden on certain people. There are less property management companies and more mom and pop landlords that are maybe unaware of fair housing issues in rural communities, and disparate impact is definitely a critical but overlooked dimension of fair housing. So it's really important in rural places for you to look at the policies that, even if it doesn't look like blatant discrimination. Slide, please. You can go through the things. Awesome. So we are here to support you, myself and my coworkers. Many of us are here. We are here to provide information about fair housing rights, whether that's in email communication or talking with us. We have tons of resources. We can do advocacy, providing referrals, and also our enforcement side can help file a claim with HUD, BOLI, or help direct folks to a private attorney. Slide, please.
We can also come directly to your agency or organization and give this information to your colleagues or your residents or your staff as well on a variety of different fair housing topics.
Yeah, and here's our contact information. Marlee and I both have our cards here if folks are interested in getting in touch. Marlee has also passed out evaluation slides on each of the tables. We would be so appreciative if you just take a hot sec and fill that out. That helps with us get better with our presentations and also allows us to continue to get grant funding. So we would be very grateful if you would do that. Yeah. Oh yeah, you can bring them up front when you're done or leave them at your table. That sounds great. Thank you all so much for being here. It was great.
Yeah, thank you. Well, let's see. Do we want to do questions? Yeah, we can do questions. If folks want to take a break, you're free to depart and get some more coffee and water, but we'll stick around for the next 5 to 10 minutes and answer any questions if folks have any. Yes. Okay.
So this question is from Kim Hunt on Zoom, and she's asking if there are any fair housing standards in Oregon for older adults 60 plus.
That's a great question. So unfortunately, older adults in age, such as like age over 65, that's not a specific protected class here in Oregon. However, oftentimes older adults fall into other protected classes, such as the protected class at disability, if they have any sort of chronic illnesses or medical or mental physical conditions as well. And when we're talking about age also in Oregon, you've probably seen 55 plus communities, 65 plus communities. Those are allowed. Those are not discriminatory unless they're not following the law as they should be. So 55 plus communities, they should have at least 20% of their housing could be available to families with children. However, in 65 plus communities, they do not need to reserve any of their housing for families with children or allow any families with children to live in those spaces. So that's the only caveat when it comes to age and fair housing. Does that answer their question? All right. Yes, wonderful. We have a question here also in the back.
So I live in Central Oregon as well, and I was recently evicted from my property as well, and it was during COVID. So I know the challenges facing there, but one of the big challenges, first of all, I didn't even know about fair housing. So if I would have known that, I probably could have fought this. But that's my question is we have a lot of minority Spanish speakers who are not aware of this, and because they're being marginalized and pushed out of our communities in big numbers and huge numbers. And the other big problem is if they raise the rent, they wind up having to move somewhere else, which is another $4,000 or $5,000 expense to move. So all their income is being depleted by these increases of rate of rent. So we're losing people and we're losing income and we're losing our, we're getting hit really hard by this. And I'm watching this exodus of communities leaving now because as a community organizer, it's a real thing happening. And I was wondering, how do we advocate for them to get them to understand their rights when it comes to all this?
Yeah, that's something that I have been working on, trying to connect with the different social service agencies and trying to do these different trainings and providing resources for folks around for housing and other social service agencies.
Yeah, we have some partnerships with some great organizations, CASA, as well as the Fair Housing Development Corporation. We have partnerships with both of them. And our hope is that in the next year, we create more language availability and accessibility on our website, in our trainings, and with our materials. So that's a barrier that we have in our organization, and we're trying to fix that. And to do more outreach to folks to teach them that they do have protection, specifically around national origin if they're being evicted, because They can't provide social security identification. Housing providers should accept all types of identification. We have a list on our website of types of identification that housing providers should be accepting. Caveat to that is if they are federally funded, then they will need to provide evidence of social security because that's a federal funding policy. But then again, that's creating a disparate impact, one could argue. So it gets a little tricky when we're talking about that. Yes, absolutely.
Hi. There's also the Community Alliance of Tenants, which is the statewide renters' rights organization, and they have staff who speak multiple languages and resources available in multiple languages, and they support tenants who want to organize as well. So that's another resource.
All right. Any other questions? Oh, and I would also encourage you to reach out to us if any cases are coming up more and more often, and you think there might be discriminatory intent behind that. Please reach out to our enforcement team. You can send us an email at enforcement@fhco.org, and we can, our enforcement team could provide an investigation, an intake, and maybe explore that matter further as well. Thank you. Yes, you should have access to these slides on the Google Drive, I think, that will be shared. I believe so. And there's also copies, of course, on those slides. And feel free to come up to Emily and I, and we can give you our business cards if you want to reach out to us personally, or you would like some other resources we can maybe pull from our library to hand off to you. All right, I think with that, we're going to call it here. Thank you all so much for joining us, and enjoy this second day of the conference. We thank you for being here.